Every day in the USA, people find themselves in court.
Gage Apple appears from the Butler County Jail Zoom location. Back on November 4th, when this matter last came before the court, there was a motion to continue trial by the defense, granted by this court to allow more time for an evaluation by Dr. Stephan. Pretrial conference was reset to today. What announcement or report would you make to the court at this time, Mr. Pate?
Your Honor, we've reached a plea agreement and Mr. Apple is prepared to plead today.
What are the terms of that plea agreement, counsel?
There will be a no contest plea to amended count 1, which will be level 4 aggravated battery. There will be a no contest plea to count 2 aggravated assault, level 7 person felony. Count 3 will be dismissed. At the time of sentencing, the state will recommend the presumptive sentence, which we expect to be prison. The state will stand silent on whether count 1 and count 2 should run concurrent or consecutive. And the defense will be free to argue for any legal sentence, including any departure motions that it feels necessary.
Sweeney, as Mr. Pate announced consistently with your understanding as to how this case would be handled?
That's accurate, Your Honor. He has.
So you're moving to amend count 1 to level 4 aggravated battery?
That's correct, Your Honor. And if it would help the court, I do have a mocked up amended information. It hasn't been filed yet, but showing exactly what the subsections and the amended information would look like if accepted.
All right, are you going to email that to me, counsel?
I was thinking I could just share the screen, but I could also email that.
You can share the screen.
Okay, thank you, Your Honor. Okay, thank you.
All right, I trust, Mr. Pate, that in your professional judgment, we don't have any issue regarding capacity here.
We do not, Your Honor, and I believe he is competent. He does have mental health issues, but he is competent. He had an evaluation done, which I'll share with the court at time of sentencing. It was not a competency evaluation, but the opinion of the evaluation was that while he has mental health issues, he's able to understand and appreciate the nature of his conduct.
Very well, Mr. Pate. All right, Mr. Apple, you've heard what the attorneys have announced this morning. Is it your intention to enter no contest pleas and accept conviction for charges of aggravated battery, a level 4 felony, and aggravated assault, a level 7 person felony?
Yes, sir. No contest.
All right. I've got a number of questions I have to ask you regarding the taking of this plea. If there's anything asked of you that you do not clearly understand, I'll give you the opportunity to confer privately with Mr. Pate at any point. Just let the court know if you need that time to confer privately with your lawyer, okay?
Okay.
All right. I'm going to have you state your full legal name for the record.
Gage Douglas Apple,
And how old are you right now?
31.
What's the highest level of formal education that you've attained?
High school diploma.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
Possibly. I'm not quite sure. I've never done this.
Well, if you do, I want to make sure that you do understand what we're doing at every step. So if you need time to confer with Mr. Pate,
Okay.
I will give that to you. All right. Mr. Apple, there's been some discussion regarding your mental state. Have you ever been adjudged formally to be mentally ill?
What was the question?
Have you ever been adjudged to be mentally ill?
What do you mean adjudged?
Have you ever been determined to be mentally ill?
Yes, I have mental health with South Central Mental Health.
All right. Are you currently taking any prescription medication to address mental health issues?
Yes.
Okay. Are you taking those medications as prescribed?
Yes.
And do you believe that taking those medications actually improve your mental state and your ability to understand things?
I do.
Are you under the influence of alcohol or any other drug?
No.
Okay, so do you believe, Mr. Apple, that your mind is clear and that you do have a full understanding of what we're discussing here in court so far?
Yes, sir.
All right. Um, did you receive a copy of the original charging document in the case, Mr. Apple?
From Mr. Pate, yes, I do believe.
All right. And did you have an opportunity to look at the screen share that Mr. Sweeney did with the new charging document?
Yes.
Do you understand the nature of the charge in amended count 1, aggravated battery, a level 4 person felony?
Well, I'm sorry, what was the question?
You understand the nature of the charge of aggravated battery?
Yes, I believe so.
And do you understand the nature of the charge of aggravated assault?
Yes.
Okay. Now, when you enter pleas of no contest, you are not necessarily admitting that you did these things, but you're also not contesting that you be convicted just the same. You understand that?
Yes.
You understand that when you enter pleas of no contest, you give up any legal defenses that you might have had to those charges.
Sorry, what was that?
You understand that when you enter no contest pleas, that you're giving up any legal defenses that you might have had to those charges.
Okay, yeah.
All right. Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses have to testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Pate, and that at a trial, you could present evidence on your own behalf and subpoena your own witnesses to court?
I understand.
Right. You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify at your trial if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes.
And you understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Okay, yes.
Are you also aware that you have a right to a trial by jury, that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter pleas of no contest, you give up your rights to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes.
Do you further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes.
Now, are you aware of the possible penalties that could be imposed as a result of these no contest pleas that you are attempting to make?
I think I understand.
We're going to go over those. The level 4 felony on the non-drug offense grid, in the most favorable criminal history category of I, you can receive as little as a 38-month prison sentence. In the worst criminal history category of A, you could receive up to a 172-month sentence. So the sentencing range is 38 to 172 months in prison, depending on your criminal history. As you sit today, Mr. Apple, we do not know with certainty what your criminal history is. You better than anyone else here should know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of their research, as of the date of sentencing, that will determine where you fall along the level 4 line, and then you'll be sentenced accordingly. You understand that?
Yes.
Okay. I also need to point out to you that under Kansas law, the entirety of the level 4 non-drug offense line is presumptive prison. Do you understand that?
I understand that.
You also understand that for a level 4 crime in Kansas, you could receive up to a $300,000 fine.
And now I understand.
All right. Let's go over the level 7 charge. In the most favorable criminal history category of I, you could receive as little as an 11-month sentence. And over in the worst criminal history category of A, you could receive a 34-month prison sentence. So the sentencing range on level 7 is 11 to 34 months, depending on your criminal history. Do you understand that, Mr. Apple?
Yes.
Do you understand the difference between consecutive and concurrent sentences?
Yes.
All right, we'll go over that too. Concurrent sentences mean that the counts would run all at the same time. When you're serving one, you're also serving the other. This would obviously result in a shorter sentence. Consecutive sentences means boxcar, back to back. You have to serve all of one before you start the next. This would obviously result in a longer prison sentence. Do you understand then the differences between consecutive and concurrent sentences?
Yes.
And do you understand that it's generally up to the discretion of the court to determine whether your counts run consecutively or concurrently?
Yes.
Okay. You also understand that you could receive up to a $100,000 fine for the level 7 charge.
Okay.
In addition to any fines, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Okay.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
I understand.
Right. You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Okay.
You also understand that the Kansas Sentencing Guidelines Act contains many special rules. Do you understand that if any special rules apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that, Mr. Apple?
Okay.
Have you had an ample opportunity to discuss these legal matters with your attorney, Mr. Pate, before proceeding here today?
Yes.
Do you want any more time with him privately now before we go any further?
Mr. Pate?
It's up to you. If you've got questions for me, we can have time.
Okay. Aside from having the charges ran concurrent versus the other option, that's really weighing a lot. So I don't have any particular questions at the moment, but I'm sure I will get questions after I walk away from the computer. But at this time, no, I don't.
Okay. Now, are you satisfied with the services and advice given to you by Chris Pate?
For the most part, yes.
Okay, what do you mean by for the most part?
I don't know all the jargon, etc., but I know he's a super busy guy. I've never gone through this before, so I don't know like what to expect in certain situations with this, and so I think I'm a little bit slower paced than Mr. Pate. It takes me a minute to really understand things, and we've only met a couple of times. And had very like minimal conversations, but I believe that the help that he has provided for me up to this day has been good. Yes.
You understand that Mr. Pate doesn't necessarily know what your ultimate outcome will be. There's discretion by the court that could be exercised, and he can't make any guarantees as to what your sentence is going to ultimately be. Do you understand that?
No, yes, I do.
Okay.
Judge, for the I just want the record to be clear. I spent over an hour with Mr. Apple out at the jail on Friday. I can pull my time records, but I believe off the top of my head, I've been out to the jail on at least three other previous separate occasions. And I've had probably 10 plus phone calls from the jail where I've talked to Mr. Apple on the phone. So I've done everything I can to be available to him. So I wanted that on the record.
Okay.
I agree with Mr. Pate.
Okay. So are you satisfied with Chris Pate as your lawyer in this case?
Yes.
Okay. Now, Mr. Apple, this no contest plea that you're attempting to make to these two charges, have they been based upon any threat or promises as to what this court will do in regards to your sentencing, or any other type of threat or promise?
Not that I'm aware of.
You understand that if there are any plea deals between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court shall consider them as recommendations, but is not bound by them. Do you understand that, Mr. Apple?
I do now, yes.
So let me ask you, how do you formally plead to the amended count 1 aggravated battery, a level 4 person felony,
No contest.
and to count 7 aggravated assault? Excuse me, that's count 2. Count 2. It's a level 7, but that's count 2 aggravated assault. How do you plead to that?
No contest.
All right. I'm going to ask the state for a concise factual basis as to each of the 2 charges. Mr. Sweeney? You'll need to unmute yourself to talk to the court.
Sorry about that, Your Honor. The state believes the evidence would show, as related by the affidavit, that on July 19th, 2024, that officers were dispatched to the address of for a emergency call. When they arrived on scene, officers encountered frantic children and a woman that had an ice pick sticking out of the left side of her skull, blood on her face and upper body. They were able to speak with the woman who was identified as Patricia Apple. She still had the ice pick in her skull, but she was coherent, and they were able to determine that they were looking for a Gage Apple as a suspect who had done that to her. While medical aid was being rendered, Mr. Gage Apple was located at a local business or outside of a local business in Augusta, while Miss Apple was being transported to Wesley Medical. They did speak with Gage Apple, and he admitted to being involved in an argument with Miss Apple. He said, in terms of making him feel bad about his overall situation and the circumstances he felt he was under, he admitted that he decided to kill her with an ice pick, further describing how he intended to drive it through her eye. He remained cooperative and rather descriptive in the way he demonstrated what had happened. They additionally then spoke with Miss Apple. She said that she had been knocked down and Gage began to stab her with an ice pick in the head. She said that she had screamed for her younger grandsons to call 911. She had puncture in her skull, of course, as well as injuries to the left eye and neck were also noted. The individuals who called 911 were 2 younger grandsons. The one being alleged in count 2 is BMA. According to the affidavits, they had witnessed Mr. Apple physically assault Patricia Apple, causing her to fall in the kitchen of her home, and that they had both been threatened by Mr. Apple that they would be killed if they did not leave their residence, which caused them to flee outside and call 911 on a cell phone that one of the juveniles had carried. And the state believes that, of course, that would have put them, in reasonable apprehension of bodily harm, given the attending circumstances and their interaction with him. And I don't think I have anything further. I think that would suffice as a factual basis on both counts.
And the court would make the finding based on Mr. Sweeney's statement that the harm caused by having an ice pick stuck into one's skull is more than trivial harm. And therefore, the court does find an adequate factual basis for amended count 1, as well as for count 2. All right, Mr. Pate, do you know of any legal reason why the court should not accept Mr. Apple's pleas of no contest to these 2 charges?
I know of no reason, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
All right, Mr. Apple, do you know of a legal reason or any other good reason why the court shouldn't accept your no contest pleas here today?
No.
The court will accept the no contest pleas made by the defendant, Gage Apple, and finds that those pleas are made voluntarily. He has an understanding of the nature of his charges and the consequences of his pleas, and a factual basis for each charge does exist. The court finds him guilty and adjudges him convicted of the charge in amended count 1, aggravated battery, a level 4 person felony, and count 2, aggravated assault, a level 7 person felony. Any other charges of the charging document are dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Mr. Apple's criminal history, and the court will set an appropriate date for sentencing. Pate, I'm currently looking at March 12th as a possible date, March 12th. Your calendar, sir?
I've got a settlement conference scheduled that I'm concerned may take the whole day, but I could probably squeeze it in if we did it like at 1 o'clock or something, if that's available.
Okay. What time does your settlement conference start?
It starts at 9, so if we
Okay.
did like shortly after lunch, I don't think that'd be an issue.
All right. Well, I appreciate the accommodation, Mr. Pate. I'm going to set sentencing in this case for 1 o'clock p.m. on Wednesday, March 12th.
May I make a statement?
What's the nature of your statement, Mr. Apple?
I was going to see if it was okay with Mr. Pate if I share the a pre-sentence letter. I don't have that at this time. But I just want to be able to like address and apologize, and I guess the additional level 7 that it just like I never wanted anyone to get hurt here in this situation, and having those kids run out of the back of the house to call a ride to pick them up while I was after this had happened, it was traumatic for everyone, and I could have been injured that day myself. But I never threatened those children. That did not happen.
Well, Mr. Apple, of course, already accepted your pleas of no contest. And quite frankly, when you enter a plea of no contest, you're not asked to tell the court what happened. I have to accept the statements made by the prosecutor as to what their evidence would show. So I understand where you're coming from, but your plea of no contest contemplates that you're not going to contest the state's factual statements if they are related to the court in good faith. And quite frankly, under the circumstances, the court believes that it's highly likely that these persons felt threatened by your behavior. But with that stated, Mr. Apple, to address your original point, at sentencing, you will be given the opportunity to make a statement to the court. If you wish to write things down and read your statement so that you make sure you cover everything you wanted to cover, I'll give you the opportunity to do that at sentencing.
Okay.
So I just want to make sure that you are aware that you will have an opportunity to make your statements to the court at time of sentencing. Okay?
Yes.
All right. And that sentencing is currently set for Wednesday, March 12th at 1 o'clock.
If I may, sir, before we hop off here, if it could be known that I wasn't arrested. I turned myself in right after this situation happened. And I was in a severe psychosis state when I came here to the jail. So I was told by the medical staff here. So I just wanted to be known that, this was not something I was running from. I'm not trying to make myself a victim in the situation, but I'm aware that we can still go to trial if need be. Is that correct?
No.
Okay. Well,
No, we covered that, Mr. Apple. You waived your right to a trial in this case.
okay, understood.
But the points that you're making are certainly pertinent.
Well, I'm not a monster. I
To
just feel like
sentencing.
Mr. Sweeney was making he's reading from what he's reading, but I could pull from the discovery about those children. I didn't even say in the discovery that those children saw what had happened. So this is just it's a god-awful situation for anyone and everyone involved, but I don't have a record. I'm not some monster. I've been sober for 6.5+ years. Aside from my mental health medication, and I've spent that entire time after quitting drinking and stuff. I just
All right,
think,
Mr. Apple, this is the time of the plea. Sentencing is where we're going to determine what happens with you.
okay,
Your statements are very well may be pertinent at that time.
okay,
And again, you will be given the opportunity to make your statements to the court. So,
I understand.
all right. Wednesday, March 12th, 1 o'clock p.m. is set for the sentencing in the case. I'm contemplating that be done by Zoom. Mr. Pate, is there anything else we need to address currently?
Not at this time, Your Honor.
Mr. Sweeney, anything further?
No, Your Honor.
Very well. And at this time, the Apple matter will currently be in recess.